director penalty notices, real-world case studies and lessons. Welcome to IO Insolvency Options with Darren Vardy, the Managing Director of Insolvency Options and a registered liquidator with over 30 years of experience helping businesses and individuals navigate financial challenges. In today's episode, Darren shares shocking real-world examples of directors who nearly faced personal bankruptcy due to outdated ASIC records and registered agent failures. He reveals how a $1.8 million DPN was avoided with just 1 day to spare, and how another director faced $50,000 in legal fees due to a liquidator's administrative oversight. You'll learn the critical importance of registered office procedures, why accountants must be more than just mailboxes, and the devastating consequences of not keeping your details current. I'm your co-host Anthony Pearl. Let's dive into unlocking more about insolvency options. Darren, let's just get a little bit more into the DPN situation, because I think this is an important topic that we need to have a look at in a little bit more detail. We touched on before about the notices going to, in a previous episode, about going to people's addresses and making sure their ASIC records and things need to be updated. I mean, talk to me about registered agents and how that works as well, and getting deeper into this process, because there's a lot of people out there who are potentially are directors and are not familiar with how all of this is working.
Sure. So what we've experienced over time is that from time to time, the registered office of the company and or the ASIC registered agent can be the company's external accountant. So in that regard, the company's external accountant becomes the company's mailbox for all important documentation. Now, be it ASIC documentation, being legal documentation, because when documents are served on a legal basis, they are served on the registered office. So it's really important that the external accountant and their staff understand the role of being a registered office and ASIC agent, and the fact that they're not just a mailbox for their clients where they receive communication in and post it out. We had a matter in Brisbane, a national IT business, where the actual address for the directors was care of the accounting firm or care of the registered office. So in that instance, we were confronted with a situation where I was contacted on the 20th day, which was on a weekend, by the director saying that he had received a director penalty notice and he needed to act to appoint me as an external administrator. Now, on the Monday, we quickly effected the appointment. So we effected the appointment on the 21st day, which allowed him to avoid any personal liability. But when we went back and had a look at why the director had received the notice on the 20th day or thereabouts, what we found was that the director's address was the external accountant. The external accountant's office had received the director penalty notice, and which was received by the receptionist. The process of the external accountant was that any communication that came in was then readdressed and re-enveloped and sent out to the director. The documentation wasn't notified to the client partner of the firm. It was just a process where documents would come in, documents would go out. Now, in this instance, the director was away overseas on work commitments, and he'd only returned home that particular weekend to find the director penalty notice in his personal mailbox. Now, that came at quite of a shock to him, because whilst being away, he'd actually been in contact with his external accountant whilst overseas, because he was overseas looking at a new project, and he was on the phone to his accountant talking about the potential profitability and running some financial models in respect to the project. So whilst personal liability was avoided, but for a day or two, it could have been a whole different scenario or circumstance. Now, the value of this director penalty notice was about $1.8 million, with the total debt owing to the tax office at that point in time was $3.3 million. So for the sake of a as I said, for the sake of a couple of days, this director could have been significantly financially disadvantaged by virtue of the addresses that were listed with ASIC and by virtue of the process employed by the external accountant in acting simply as a mailbox and not elevating the seriousness of the notice to the client partner of the firm.
I think there's a lot of lessons here to go through and learn. And I think let's just start off with the basics. In terms of director, one of the first things I gather you should be doing is, first of all, working out what actually is your registered address with ASIC in the first place.
Correct. And that is just a simple search of the ASIC register. Every 12 months, ASIC will issue an annual return, and that will have the company's details on it: directors, shareholders, registered office, principal place of business, and the like. So whilst a lot of companies simply receive that document from their external accountant or ASIC agent, pay the necessary fee to ASIC, it's very important that everyone really looks at that annual return document to ensure that the addresses are correct. Because if they're not, and there is, say, some legal documents that need to be issued, and they're being issued to an old address, well, then all of a sudden what you can find is that you can be at the end of a piece of litigation without your knowledge and trying to defend the fact that you never received any documentation. I have a situation with a friend of mine, actually, which is not dissimilar, where what happened to him was that he had a superannuation debt outstanding at the time that his company was placed into liquidation. Now, what he found was that the ATO had subsequently issued a DPN in respect of SGC, which is outstanding super, or what they call superannuation guarantee charge. Now, this was one of those lockdown DPNs. The notice in this instance was actually issued to the liquidator's office. Now, the liquidator's office, upon the appointment of the liquidator, had changed the registered office to the liquidator's address. And that's not uncommon. But it was also found that because the director's address was listed as the registered office, the director's address had changed to the liquidator's office as well. The problem, however, in this instance is that when the director penalty notice was received by the liquidator's office, staff of the liquidator simply filed the document because the company was in liquidation and they did not notify my friend, the director. So I would say 18 months to 2 years later, when doing his personal tax return, his tax accountant noticed there was a new debit account on his personal profile on the tax portal, which related to the company's SGC debt. Now, his accountant made some inquiries and only to find out that the ATO had formally commenced recovery proceedings to recover the money, and they were actually trying to locate him as his residential, to personally serve him with legal documents, because the current residential address was not correct. And since liquidation, he'd actually moved residential addresses anyway. So that actually then led to my friend having to formally engage a lawyer to deal with the legal proceedings that were on foot or had been commenced by the ATO. Whereas if the DPN had been passed on by the liquidator's office 18 months earlier, what he could have done was engage proactively with the ATO and organise a repayment arrangement for the monies owing, as opposed to having to formally spend money with lawyers to defend the proceedings, but essentially come to the same outcome, which was organise a payment arrangement to repay the debt.
A much more expensive outcome once you start employing lawyers.
Correct. And the outcome was north of $50,000. So we're not talking insignificant amount of money. And that was the cost of lawyers to deal with the proceedings, as opposed to him just deal with the ATO directly.
And what would have been the consequences if he had not employed the lawyers? How would that have played out?
Well, the consequences would have been is that it would have been far more difficult for him to get to an outcome. But I think the real consequences would have been is that if he had not have become aware of the SGC debt on his personal profile on the ATO portal via his new accountant, the consequences could have been that once the ATO had located his current place of residence, they could have personally served him with a bankruptcy notice, which was the final stage in their recovery process.
Big consequences when you start going down that path, particularly if it couldn't be avoided.
Correct. And then, having been issued with a bankruptcy notice, there is only very limited time to then deal with same, which will add to more costs. So ultimately, he would have had to engage a lawyer and incur far more legal fees to deal with setting aside a bankruptcy notice, then going and dealing with the taxation office to get to the ultimate outcome which was achieved.
So in this particular case, or in the various cases, how much emphasis is there on accountants to actually make sure that the records are up to date and they're not just acting as a registered office effectively?
Well, look, the onus does come back, in my view, back to directors. My experience is that accountants will issue the annual return notice each year to ensure that to the director clients and ask them to ensure that all the details in the annual return is correct, i.e. make sure that the addresses are accurate.
Yeah, and I think that's one of the key things, isn't it? Because often when you get information from an accountant, the first thing you're focusing on is little things like how much money is owing and the bits and pieces in between. But something as simple as an address can be easily overlooked.
Correct. And when the accountant sends out the annual return, it does come with the ASIC invoice, and the ASIC invoice may be for $60 or $70. So quite often people focus on, I need to pay this ASIC invoice by the due date, otherwise I'll get a fine. Let's get that paid. But they don't look at the actual return, which can be far more important in these circumstances.
Yeah, it's a very important point. And I think I want to emphasize something that you mentioned earlier on as well, is that it's all about physical addresses. And why is it that they don't use emails? Because emails don't change as often as addresses do.
Look, this is a legal thing. The majority of legal notices when we're dealing with the recovery of debt must be personally served when it comes to individuals. If an individual cannot be personally served, an application can be made to the court for what's called substituted service, whereby evidence is provided that you've attempted to serve an individual at the last known address, but you have that individual's alternate address or email address, and you can actually apply to the court to serve via email. But it's something that can only be done after you have exhausted all efforts to personally serve them at the last known address.
And certainly from a director's point of view, though, that's the key is that you're not going to get things in an email. You're not going to get a phone call. You're just going to get something physically. So if you haven't kept that up to date, then the onus is on you.
Correct. This is true.
So just wrapping up this discussion directly, and I guess the outcome for your friend was obviously as positive as it can be in the end. And is that something that is common? What are the steps that people should be taking other than getting your address right?
Look, it all comes back to act swiftly. If any of these notices are received, it's a matter of acting immediately and not waiting to the 21st day to seek advice.
And that's all we have time for in this episode. But next time on IO Insolvency Options, we'll explore a detailed case study of a national IT company facing a $1.8 million directive penalty notice. Darren will walk you through the entire voluntary administration process from emergency appointment to successful deed of company arrangement, revealing how creditors received 66 cents in the dollar instead of just 33 cents through liquidation. It's a masterclass in business rescue you don't want to miss. For details on how to get in touch with Darren and his team on insolvency challenges, please consult the show notes. This podcast is produced by my team at podcastdoneforyou.com.au, helping professionals share their expertise through powerful podcast content. If you found value in today's episode, please like, share, comment, and subscribe to IO Insolvency Options so you never miss an episode. Until next time, remember, there's always a way forward when you know your options.